I'm in a recliner.
There you go.
And
which
we'll,
I need to change around.
Okay, well, I'll begin. For the record, Ben Novogrowski from the Office of Legislative Counsel. I'll really quickly try to get through 40 pages in 10 minutes of S195. Thank you. So let's just use the side by side as the kind of guide for the moment. So the House did vote out the bill yesterday, the day before. So it did merge what is now the House Judiciary report and the House Corrections report are now just the bill. And there was a small change on the floor that I will highlight that's not reflected in the side by side. I believe that we ended on home detention. So if you go to 1, 2, 3, the fourth page of the side by side, entitled Section 3 and then 13 VSA 7554B. This is the home detention statute, and basically what has happened in this statute is that they have left the current home detention, which can be imposed on individuals that have that bail has been imposed, they have failed to pay bail, and they've been incarcerated for 7 days. They are currently eligible to be placed in home detention as an alternative to incarceration. That remains untouched outside of two very small changes. Right now, only the department or the court or the defendant can ask to be placed in the current program. It adds the prosecutor now as someone that can request such a placement. And then just really a terminology change to ensure that mitigate defendant's risk of flight is the term that's used rather than something else that's akin to it. So if you'll see though on the next page, you'll see that there were some changes that the House conducted, and this is the expansion of the home detention program. So right now what the House has decided to do is expand it for those that have violated conditions and that the person poses a significant risk to public safety. That is essentially the eligibility threshold. That if you violated conditions and you're deemed a significant risk to public safety, you can be placed in the program. There is a failure to comply. So if you look on the next page, you'll see on the side by side that there's language saying that at arraignment or after a court hearing, the court may be provided the court may order the defendant be released in home detention, provided the court finds placing the defendant will reasonably mitigate the defendant's risk of flight, risk of non-appearance, or reasonably ensure protection of the public. That language was struck on the floor of the House, and now it reads that the person poses a significant risk to public safety. Placing the defendant on home detention will mitigate such risk, and the proposed residence is appropriate. So that's the change from what was contained in the side-by-side to what was actually done on the floor yesterday. Any questions as far as the eligibility threshold? Seeing none, I'll move forward. So failure to comply, if someone, the department, so if someone's placed in home detention, the department supervises them. It's a condition that can be ordered by the court that's added through other portions of the bill. And so the department has the discretion to report a defendant's unauthorized absence or failure to comply with any other condition of the program to the prosecutor and to the defendant, provided that essentially the violation wasn't due to the fault of the individual themselves. So basically if if they have an electronic monitoring bracelet on while they're on home detention and the battery dies, that's not necessarily their fault, just sort of an administrative error. So that's something that wouldn't be counted towards them. And in addition to that, the officer has discretion to report any violations. So there's flexibility there. But once a violation is reported, the prosecutor has the option to request a review of conditions to see if something needs to be changed, whether or not the person should be prosecuted for contempt under 7559, or bail should be revoked altogether under 7575. These are really options that are available in other circumstances anyway. It's just in this expansion being enumerated, and it's really just the options that they would have under current law. If this was expanded and these weren't enumerated, they could do these things anyway, but it's just outlined here. The department may contract out for services, and the change was to any public entity, not public or nonprofit, because there was testimony that no one is aware of any nonprofit entity that does this type of work. So it would be any public entity. And that doesn't necessarily have to be the state.
Ben, thanks for waiting. It took a little longer than I expected, and I want to give members of the committee a chance to get a little break. So if we could schedule continued walkthrough tomorrow morning on this, and if you have time, and have 9 o'clock. And at that time, the other request I have is if members can go over 250, the Climate Superfund bill, and if you would support the House changes, let me know through email, either through Ben or yourselves directly to me. If we need to, we can take it up tomorrow morning since we'd be concurring. So I'm not even sure we get to it today, but I don't want to lose the bill, that bill. But if it's going into approps, it becomes problematic. And my biggest concern, Ben, is they're taking out the ability to have pretrial supervision, and that's just,
Is that being discussed right now?
Well, by not allowing the positions,
right?
Who's going to supervise?
Well, those
Thank you
the positions that I understand that they're proposing of taking out would be the